Unplug 1 and get some light over here for you, for the kid. Get some light for the kid. That's cool. That's the cool beans. That's the cool beans. Cool beans. Legal research. Take the law into your own hands. That's what this is all about. Taking the law in your own hands. Okay. You know what I'm saying? Listen. Do you have legal questions at home, at work, or as a part of a law-related course? Legal research provides everything you need, laying out easy-to-follow research methods that will help you find the right answers. Find out how to locate and understand statutes, regulations, and cases. Make sure your research is 100% up to date and organize your research results into a memorandum of law. Memorandum of law for use at school, at work, or in court. Completed the 19th edition. Legal research shows you how to find statutes, cases, background information, and answer specific legal questions online. Even more important, you will be guided to the most reliable and user-friendly sites, so you won't be drawn into an information flood. So, hold on. What are you doing, dog? You all right? Want some light on in there? Good, dog? Cool. All right, back to this. Legal research. See, I'm going to find out what I need to know. I'll go to my library, go to the library and find out what I need to know. This is what we're going to read to you. This is your legal research companion here. If you're new to legal research, you might be apprehensive about finding, understanding, and applying the law. Whether you're in a law library or at a computer, it's common to feel like you're searching for the proverbial needle in a haystack. After all, there are many different research resources and a lot of places to look. Fortunately, legal research isn't as difficult as it might seem. And with my help, you'll be finding everything you know. Not only will you get help with navigating the legal research process, but also covering the basics of law so you understand what you're looking at, where to find legal resources, and know where to start, how to frame your legal issue so you approach your research efficiently, how to find and use legal resources like statutes, cases, and secondary sources that explain the law, how to validate your research results and ensuring you're using current law, and how to organize your research and put it to use. So, sum it all up. When it comes to finding what you need, don't fear. It's out there. Get it? It's out there. Understanding the basics of law. Trying to research the law can be a daunting task. Fortunately, online research has made it so that that's no longer the case. Fortunately, Today, many people find it easy to do their own legal research when they need to resolve private disputes, understand and work with a legal professional, and advance an academic or professional career. Often, legal research can be done in the comfort of your home or office. The goal is to help you find the resources that you need to conduct legal research and explain the steps you'll take to ensure you're using the correct law. Okay, so listen, before we get started, it would help to have a basic understanding of how the law works. So, first, we're going to cover what is law, the sources of case law, statutory law, and administrative law, the difference between state and federal, and the structure of the U.S. courts. This framework is to help you understand how to conduct legal research, help you draft legal questions, and more importantly, find the answers you need. Bingo. What is the law? Most of us don't spend time thinking about what the law means. The law. What is the law? In the real world, we don't get along fine without this knowledge. No one needs to see a written law to know that it is a crime to steal or destroy someone else's property. And we know that we can be held responsible by our legal system. So the law doesn't play much part in our daily lives until we get a traffic ticket or denied a government service, buy or sell a house, or dispute a bill. But when that happens, we need to know the rules of the game. The first step in understanding where particular types of law come from, because it makes it easier to find the law that applies to a particular problem. So that's where we're going to start at. That being said, knowing that law applies in your matter doesn't mean it's always functioning predictability, although that's the goal. After all, prosecutors choose whether to bring charges against defendants, so committing a crime doesn't necessarily lead to prosecution. And while we might be entitled to a government service, a Social Security payment, for example, that doesn't help much when the Social Security Administration denies the claim. The reality is, laws are applied by real people in the world, so things don't always play out as perfectly as we might want or expect. Even so, successful litigation starts with solid preparation. At first, and the first step is finding the law that applies to your case. So, sources of law. You won't find the law in a single set of books. Instead, it might be made up of numerous separate collections, and one might apply to any given situation. Here are the general categories you can expect to encounter: the U.S. Constitution. The high-level comparatively short document explains how our legal system is structured. It outlines the responsibilities of the three branches of government. It also describes the authority retained by the federal government and gives the remaining powers to the states. The amendments guarantee citizens fundamental rights, such as the right to free speech and to bear arms and to limit what the government can do. Federal statutes, as we'll explain below, Congress frequently passes new laws that are compiled in code books. These laws are called statutes. Federal cases. Federal courts decide cases about federal law and how to interpret federal statutes. How the statutes should be applied in certain situations isn't always clear or even anticipated. They also hear cases between two parties that are from different states. Federal administration regulations. The legislation cannot write all the statutes need to regulate society. There simply isn't enough time. Instead, the legislature shifts specific lawmaking authority to government agencies through an enabling statute. For instance, agencies like the Equal Employment Opportunity Commission The Internal Revenue Service and the Environmental Protection Agencies are created by the U.S. Congress as a part of and overseen by the executive branch. They issue regulation laws and with regulation law using the authority granted by the enabling statute. Regulations are in part of the federal administration law. Caution. Sovereign Native American tribes have their own courts and laws. These are functions outside the system we describe here and beyond the scope of this book. State constitutions, like federal governments, state governments have constitutions that form the basis of their legal statutes. State statutes, like Congress, state legislatures pass statutes which constitute state statutory law. While federal law applies everywhere, these laws only apply within the state. State courts decide cases about state law. State administrative regulations, state legislators create agencies to regulate particular areas of law. Agencies write and enforce regulations that constitute state administrative law. Local ordinances. Local governments pass ordinances that become policies, codes, building codes, planning codes, health codes, and so forth. Your legal researchers will probably touch on only 2 or 3 of your legal sources in most cases. For example, if you want to sue your automotive mechanic because you got into an accident after he failed to fix your brakes properly, you turn to state statutory and case law. You won't need to look at the federal constitution or local ordinance. We'll explain about these sources of law below. Constitutions. Both the Constitution and the Federal Commission are the founding documents that form the basis of authority for all other forms of law. That is, they tell the various branches of government what authorities they have to create new law. As we'll explain below, legislatures and judges create law, but that law cannot conflict with the Constitution. Statutes, legislative made law. What most of us tend to think is when we think of the law, what most of us tend to think of when we think of the law are the acts passed by our national and state legislatures. We might understand, for example, that Congress has decided the income tax rate, or that our state legislators have determined that it's illegal to discriminate against someone in the workplace based on sexual orientation. The statute comes into being when the legislator passes a bill. The text is written down and given an identification number and arranged in a numerical order in a code book or codified. As new bills are passed, existing statutes are amended, or the laws are incorporated into the existing code. Collectively, they create what are known as codes or statutes. Both federal and state statutes are grouped together by subject matter. For example, California Family Code includes most of the law that affects the families facing divorce, illegal separation, and child custody disputes. At the same time, Title 12 of the Connecticut Code deals with the state taxation. This organizational system makes finding relevant materials much easier when it's time to do the legal research. We'll discuss how to use and discuss statutes in greater detail later. Common law, judicial interpretation. While statutes are essential part of our law, they actually make up a small part of it, because we don't always agree on what the statute of the Constitution mean. We need courts to provide guidance and to explain how to apply them in particular situations. As a result, interpreting these laws is primary responsibility of our court system. For example, in a child custody case, the law might say that the judge decide the custody with the best interest of the child in mind. The child's mother might think that means living with her with occasional visits to the father, whereas the father might feel the child should live with part-time with each parent. On each side, the parties have different interpretation of the meaning of best interest and how the law applies to them. In this situation, a judge will look at the case law to see how previous judges handled factual situations similar to the one before the judge. Doing so will help the judge determine what the best interest means in light of the circumstances of the people involved in the lawsuit. So how do these cases come about? Judges sometimes create a document called an opinion. That explains the judge's rationale. Judicial opinion form what is called a common law or a case law. It is the judge's view of what the statute means when applied to the particular facts of the case before the court. Common law is developed over time as an opinion builds on one another. Most jurisdictions require judges to follow the logic of certain earlier opinions. So you won't find common law written down in one place. Like a structure, a statute that sets forth a clear rule. Instead, the court publishes opinions in books called reports or reporters. Federal and state courts have separate sets of reporters which organize opinions or cases by date. Because common law is part of the law, judges have to consider not only what statutes say about what judges before them have said on the same issue. In other words, court opinions serve as an authority or a precedent that other judges are usually required to consider when deciding similar cases. The reasoning in previous cases that a judge is required to follow is called a binding authority. But courts are arranged in a hierarchy. Every judge isn't required to consider every other judge's opinion each time a similar issue comes up. Just the opinions of the court above them in the same jurisdiction. As a result, you'll need to know which judicial opinions to review when researching a legal issue. I'll explain more about how to do that later. Okay, sidebar. It's about the judge. Sidebar. What if a judge is wrong? The system of judicial precedent works well when judge correctly interprets the law, but sometimes they don't. For example, what if a judge decides, as did many years ago, that it's okay to segregate people based off of their race? Is a judge bound to follow a law that is wrong? Fortunately, the answer is no, but judges don't often deviate. So don't expect a trial judge to disregard existing law. Judges respect the legal principle called diuresis, Latin for let the decision stand. Unless there is an excellent reason to depart from the current law, judges don't. Most lawyers will tell you that they never had a trial judge disregard current law. Instead, trial judges expect litigants to seek legal change to appeal the case to a higher court with authority to do so. So every judge's decision isn't destined to stand forever. Also, courts recognize mistakes. Take current social values courts recognize mistakes. Take current social values more into account, and in rare instances, liberally interpret the law to fit the desired result when so inclined. But the principles of stare decisis is a strong one. The reality is that no one, including judges, want to be found wrong or appealed in a judge's case. So judges are reluctant to disregard well-established rules when necessary. Will take pains to explain and justify significant departure from previous decisions. So what is the takeaway? Convincing a judge to diverge from the law could take a stellar advocating on your part. So it is best to confine your arguments those to fitting those that fit within existing law. However, okay, back to the bar. Back, get off the sidebar. Back to the main bar. However, if Congress disagrees with a court's decision, it can usually pass a new law that contradicts it. This isn't true if the case interprets Constitution, because Congress' powers to legislate can't conflict with the Constitution. For example, Liddy Ledbetter sued her employer claiming that it had to discriminate against her by paying her less than her male peers. But the Supreme Court held that she had filed her lawsuit too late and upheld the trial court, which had thrown out the case. Ledbetter versus Goodyear Tire and Rubber. The court decided Ledbetter hadn't met the legal requirement to bring her claim within 180 days. Because the decision to pay Ledbetter less had happened many years before, Ledbetter argued that each time she received a paycheck for less than her peers, it was a continuing violation of the law. So 180 days started to run from when she received her last paycheck. Even though the Supreme Court disagreed with Ledbetter, Congress passed the Liddy Ledbetter Fair Pay Act shortly after that, taking Ledbetter's side. Now, employees in the Ledbetter show Ledbetter's shoes have the benefit of the act. Without it, court would be required to treat those employees the same way the Supreme Court treated Ledbetter better. That's administrative regulations. Both federal and many state governments have administrative agencies that work in specific areas of the law. For example, the U.S. Department of Labor oversees the wage and working conditions of the nation's workers. These agencies are created by Congress and state lawmakers, but are under the leadership of an executive branch, either the president or a governor. The agencies are given by authority to adopt regulation that specify how certain laws will be carried out. While Congress passes laws that provide the framework of how laws is implemented and enabling statute, regulation often provides detailed frequency based in the experience and feedback from citizens who have questions about the law. For example, while a mileage reimbursement rate is part of federal law, the amount that rate is set by each year is set by the IRS. Local ordinances. Some areas of the law aren't covered by state or federal law, or at least aren't covered completely. In that case, local bodies like city councils or county boards have the authority to regulate. You may have come across local ordinances if you have needed a building permit or have questioned zoning laws. For example, often these ordinances are enforced and regulated by the bodies that create them. And there are opinions to resolve disputes that don't involve the court system. For example, appealing by a decision by a local planning commission might require a hearing before the commission rather than going to court. State versus federal law. The law comes from more than one source. The primary sources are state law and federal law. Though we've explained local bodies regulate some areas, describing the difference between state and federal law could send us into a long-winded explanation of constitutional principles, but we'll try to keep it simple. The main legal text that creates federal law in the U.S. Constitution. The Constitution lays out specific areas that the federal government regulates fully without state intervention. For example, maritime law. Then there are areas the federal government is allowed to regulate. And finally, the Constitution says that states can regulate areas that the federal government doesn't regulate. Of course, that falls within each realm and has resulted in a lot of judicial interpretation and opinion. And there are many states that are regulated by both state and federal law. The general principle, however, is that certain areas, federal taxes, immigration, bankruptcy, for example, are governed solely by the federal law. The areas the federal government doesn't regulate, such as landlord-tenant law, are primarily regulated by the states. Issues covered by state law. Each state has its own set of statutes as well as common law. Most states have laws regulating the following areas: child custody, conservatorships, contracts, corporations, crimes in most cases, divorces, doable powers of attorney for health care and financial management, guardianships, landlord-tenant relationships, licenses, businesses, and professional, living wills, motor vehicle partnerships, paternity, personal injury, probate, property taxation, real estate, trust, wills, workers' compensation, and zoning. Except in rare cases, for example, the federal government regulates disclosure of lead-based paint hazards in residential rentals. Federal law will not cover these issues. Issues covered by federal law. For most of our country's history, federal law was limited to courts' interpretation of the U.S. Constitution and the Bill of Rights, as well as the topics that Congress is specifically authorized to address under the Constitution, such as regulation of commerce and immigration. But its courts have interpreted the Constitution to allow the federal government to regulate more areas. Federal law might control a broad range of social welfare, health, and environmental issues. Federal law generally controls areas like agriculture, bankruptcy, copyright, customs, food, drug regulation, immigration, interstate commerce, maritime activity, patent, social security, and trademark. Issues covered by both state and federal. A large number of legal areas are now involved in both state and federal. Federal and state governments are concerned about the environmental law, consumer protection, and the enforcement of child support statutes, and the Constitution doesn't limit who could do that. This is primarily true because the Constitution authorizes Congress to spend money for the general welfare, and it creates programs under which federal funds are offered to state governments under certain conditions. Usually, states must meet conditions and contribute financially too. A good general rule is that if the federal funds are involved, at least one element of the federal law is at play. When states participate in one of these programs, typically federal law gives more latitude in how the program is conducted. So states pass their own laws and regulations to govern the operation. Of course, courts interpret these statutes and regulations to create common laws on these issues. Areas covered by both state and federal law include consumer protection, criminal law, employment, environmental protection, health law, labor law, occupational safety, subsidized housing, taxes, transportation, unemployment insurance, veterans benefits, and welfare law. If you have a problem that is affected by both federal and state law, you might have to look to both state and federal law resources to get firm handle on your problem. The court system. As explained, in drafting opinions that interpret the law, judges are bound by other judges' opinions. But judges don't have to follow every prior opinion in interpreting the statute. Courts are arranged in a certain hierarchy, which makes judges bound by decisions of only those higher up in hierarchy. How courts are structured. Both state and federal courts are structured similarly. If you wish to bring a lawsuit, you will usually have to file a suit in the trial court. This might go by one of several different names. For example, the Superior Court, the Municipal Court, or the New York, confusingly enough, Supreme Court. But the functions of this first court is the same. Everything up to including trial will happen here. For the most part, trial courts do not issue opinions that other courts are required to follow. After a trial court, the next level up is called the appellate court. If you feature final resolution in the trial court, for example, the judge rules against you and you believe the decision is wrong, you have the right to appeal the decision. In most instances, the appellate court role isn't to start the trial over, hearing the evidence against. Instead, it will look at what the trial court did and decide whether it made any mistakes. Appellate courts often issue opinions. and those opinions are binding on the trial courts below them within the state. The highest court is usually called the Supreme Court. In states without an intermediate appellate court, appeals go straight to the Supreme Court of that state. Sidebar again. It's a sidebar. Most cases don't go to trial. Even though our court system is set up to decide cases at trial, this isn't what happens in a variety of disputes. Here are some of the most common reasons why charges are dropped. In criminal cases, prosecutors might decide not to pursue the case for several different reasons. They find new evidence that change their minds, and they do not think they have enough evidence to convince a jury, or they do not have the time or resources to deal with the case. The parties reach an agreement. In a criminal case, this is called a plea bargain. The prosecutor and defendant might agree that the defendant will voluntarily plead guilty to a lesser crime with lesser penalties. For example, a misdemeanor theft charge instead of a felony. In civil suits, the parties might settle the case, perhaps with the defendant agreeing to pay something to the plaintiff but less than what was asked for. The court might rule on a dispositive motion. To avoid wasting court time and resources, parties can ask the judge to issue a ruling or an order before a case goes to trial. Some of these rulings have the effect of ending the case, and those decisions can be appealed. Finish with the sidebar. Back to the book. The Supreme Court is another appellate court and will usually only decide whether the court below it interpret the law and applied it to facts. It won't gather new evidence or start things over, except in certain kinds of cases. For example, death penalty cases. Most Supreme Courts get to decide which cases they will hear. If you don't agree with the appellate court decision, in most cases, you can talk to the Supreme Court to hear your case. If it refuses, the appellate court's ruling stands. There are all kinds of exceptions to this general structure. For example, in many states, claims under a certain amount are heard in small claims court, not the trial court. The trial court might act as an appellate court or review the entire case. Like new, this is called a de novo. Or if you are filing bankruptcy and your creditors challenge it, the federal bankruptcy court will decide the dispute. We can't point out every exception to you, so you might have to do some research to figure out the procedure in the applicable court system. Federal courts. If you have a lawsuit that includes a federal issue or is otherwise within the court's jurisdiction, meaning it covers an area that federal laws or federal courts are allowed to hear, you can file it in federal court, called the U.S. District Court. You can't file your lawsuit in any district court, however. As we'll explain, you can file it in federal trial court called U.S. District Court. As we'll explain in a later chapter, there are rules to prevent you from showing up at a Nebraska courtroom if you are you and the defendant both live in Oregon, and the incident that resulted in the lawsuit took place in Oregon. There's at least one district court in every state, with often more breaking into the regions. District courts usually don't issue published opinions. Opinions considered binding on the other courts. Though other courts might take these decisions into account. Above the district court is an appellate court called the circuit court in the federal system. There are 13 circuit courts divided by areas of the country. Most of the circuit courts are numbered except for the DC circuit in the federal court circuit. The first to 11 circuits are covered specific parts of the United States, while DC and federal circuits are based in Washington, D.C. The D.C. Circuit hears appeals from cases in the District of Columbia, while the Federal Circuit deals with nationwide claims based on particular areas of law, including international trade, government contracts, patents, trademarks, specific money claims against the United States government, federal personnel, and veterans benefits. The circuit court's decisions are binding on all district courts that are a part of that circuit, but not on the circuits of the districts and other circuits. For example, the Fifth Circuit includes Texas, Louisiana, and Mississippi. If the Fifth Circuit issues a ruling, it will bind all district courts in those 3 states. However, it will not be binding in the 11th Circuit. The 11th Circuit might consider it persuasive, meaning it might find a logic compelling and might consider to craft its own decision, but it is not bound to do so. Want to find the federal courts where you live? Go to www.US Courts Locator, or you can go to Pacer. Pacer. At the very top of the hierarchy in the federal court system is the U.S. Supreme Court. Most of us have heard of the U.S. Supreme Court, and maybe even some of the major cases that have come out of it. And as of this year, been challenged since this book has been been overturned. For example, Roe versus Wade, Brown versus the Board of Education, Bush versus Gore. The Supreme Court has 9 members appointed to an unlimited term by the United States President. As appointees who don't have to worry about re-election, the Supreme Court is supposed to be less politically based than the legislature or the president, except for appeal of rights. Those situations in which parties have an automatic right to Supreme Court review, the court chooses which cases it will hear. Very frequently, the courts will select cases involving conflict in opinions and circuits. So if the 9th Circuit says it's okay to do something and the 5th Circuit says it isn't, the Supreme Court might issue a rule that will bind both. All federal courts must follow the Supreme Court's decisions. State courts, most state courts follow a similar structure to the federal system. Usually, the only state court opinion published are those by appellate courts, including the state Supreme Court. It is important to recognize that the state court's opinion do not generally bind federal courts and vice versa. This makes sense. For most parts, the federal courts are dealing with federal laws and the state courts are dealing with state laws, so neither judicial system tells another how to interpret its own laws. But it gets tricky when a state or federal court system must interpret each other's law. This happens, for example, when both state and federal issues are part of a single lawsuit. Let's say you believe your employer discriminated against you based on your race. You might file a lawsuit alleging that your employer violated federal and state anti-discrimination law. But it wouldn't make sense to have 2 different cases in 2 different courts with 2 different judges. So you're permitted to bring both claims in one place. If you choose state court, the state court will have to. If you choose state court, the state court will have to apply federal law to decide whether your rights under federal law have been violated. If there's an issue of federal law that the judge must interpret, the judge will turn to federal law to find an answer, not state law. In that case, the judge is bound by federal law. All right, that's it for that chapter. We'll see you the next time on that one. Legal research, how to find and understand the law.